So, Lisa, how do clients that are in mediation make sure that their agreement is legally sound?
So first off, as I indicated in a prior clip, which hopefully you've seen on the topic of mediation in California, it's really important to understand that the mediator himself or herself, they're just facilitators of settlement proposals back and forth. Once it comes to the drafting of a settlement agreement or a judgment, it's really important to know exactly what terms are being put in there because the drafting can be either very favorable to you or not. If the terms are not well stated, it's possible that you could be stuck with capital gains taxes you never expected or income taxes you never expected to pay. And then you don't want some nightmare to come up later where you didn't realize that like certain things weren't being deducted or whatever the case may be. You didn't get that exemption that you thought you were getting, whatever it is. But in the end, there's too many topics to actually talk about. I can't get into too much depth here, right? We're just going to cover this very high level. But we, as the attorneys, are responsible to understand California law and also all of the implications of the terms as they're drafted. So when you have that agreement in hand, it's very important that you have somebody understand the agreement terms, compliance with California law. You don't want loopholes and you don't want something that's all unenforceable, right? If it's unenforceable, it's going to leave you vulnerable. You're going to be at risk. You can have future litigation. I've seen it happen over and over again. Some people, sometimes they'll go to document preparation service firms. I've had one case where the couple, nobody put in what was happening with the proceeds from the sale of a residence. And one person thought that they weren't being paid. And actually the funds were wired to a bank account. They actually did get paid. And it was just a mess because the person who prepared the document never really demonstrated how they got paid through the division of these bank accounts. If it's not in there and it doesn't say it, and somebody later thinks they've got, the short end of the stick, it's not written. So it makes it, kind of just leaves you open and vulnerable to future disputes. So my thinking here, I guess my bottom line is, if you can get an attorney, and I don't think you should be penny wise and pound foolish about it. Usually there's enough at stake there that I would encourage almost everybody to get a consultation with an independent consulting attorney to a mediation, and not to leave it open to chance and not to DIY it, especially if you have children and custody parenting issues in there, if you're getting spousal support and or division of property, anything that's not a summary dissolution. Effectively, you probably should have counsel, and because there's huge financial and legal implications in those agreements, I think you should have counsel to review those. Even with hiring a lawyer to consult, overall, your mediation process is still going to be more peaceful. It's still going to be more cost effective, and you'll be protected in the end with those terms. Whereas if you try to DIY the whole thing yourself, you're just going to be leaving yourself way more open to problems with that agreement and enforcing it.